Hi, I want to welcome you to our Crime and Delinquency course, and I believe this is one of the most interesting sociology courses that we offer here at Eastern, and I hope that you guys will enjoy it as well. In our first chapter, we're going to talk about the juvenile justice system, and in order to talk about the juvenile system, I think we need to talk about what a juvenile is. And a juvenile is considered to be an individual who is physiologically, emotionally, and intellectually immature. So we had our separation of adult judicial system and the juvenile system over 100 years ago, and the first juvenile system was established in 1899, and the underlying premise of the first juvenile court system was that of patrens patriae, which is the Latin term for the doctrine that says basically that the government is the father of the ultimate guardian of all of the people under a disability. And here in the United States, that mostly means either those suffering from a mental disability and or children. And this doctrine states that children's care is just entrusted to their parents, and that the government is the ultimate guardian. This law, if you will, comes from the English common law, where the king was considered to be the father of the country, and so the ultimate guardian. And so this is all about, this juvenile justice system is really about the state's responsibility to protect its children and youth. And the juvenile justice system became a system which was intended to be a legal setting where the children and the youth could come and account for their wrongs and receive official protection, which really sounds like a great idea, but there is some issues. And one of the biggest issues that we're going to talk about while in this course is that we talk about this juvenile justice system like it was a single entity, but there's actually 51 different juvenile justice systems besides the federal juvenile justice system. So while we talk like everything's going to be the same, as you read through your text, you're going to find that it says, oh, well, the law says this. Well, except for in these judicial systems, these juvenile justice systems, which is a little bit different. So we'll see a lot of differences in ages and those kinds of things. So 51 different systems, that's a lot. So there's a lot of differences there. When you talk about the scope of the juvenile justice system, you need to remember that it's acting in that parent role. So not only does the juvenile justice system accommodate children and youth who have serious problems, so those who are neglected or abused, but they also are responsible for that parental role in the ones who are problems. And some of those commit very serious violent offenses, as you hear on the media very regularly. A status offense is one of those acts that if it was committed by an adult would not be considered a crime. So smoking cigarettes, staying out past curfew, there's several different things like that, drinking alcohol, that comes under the status offenses. And so those would not be an offense if they were committed by someone over 18. It would just be a choice. But since they're under 18, it's a crime. Well, no, not a crime because they're juvenile, but an offense. A juvenile delinquent is a youth who commits an act that would be a crime if they were over 18. So, or if it was committed by an adult. The term delinquent, which we will hear quite a lot as you read through this chapter, we use that in place of the word criminal. And the reason that we use that is because we don't want to stigmatize these young youths by calling them criminals. And that's also why they call it a offense rather than a crime. Most of those status offenses that I talked about, that the things that wouldn't be a crime if they were done by someone who was an adult, they very seldom ever are processed through the court system. Most of those have alternate dispositions. You just very seldom see those in a court case. And the age that a child comes under the juvenile court jurisdiction is established by each of the different states. So we are going to see some differences there. Most states have an upper limit of juvenile jurisdiction in abuse, neglect, and dependency cases, and also in status offenses. And typically that's through age 20. Many states, though, do exclude married or emancipated juveniles when they're looking at juvenile court jurisdiction. So the youngest age for juvenile court jurisdiction in delinquency matters usually ranges somewhere between the age of 6 and 10. So I'm going to stop here. Go ahead and get started reading your chapter, and then come back and take a look at part 2 and part 3.